If you are going into family court, don't do these things because it will upset your family court judge. I'm Rebecca Rini. I'm a family law attorney. I've been practicing law for 15 years and I've seen a lot of things. If you're going into family court, don't do these 5 things because you will piss off your judge. I know you think that you're just going to go into court, you're going to tell the judge what happened. The judge is going to see and understand and see your side. Of course they are. No, they're not. The judge really does not care. The judge wants to get through this as quickly as possible. The judge is a stranger. So think of it, if you go up to a stranger on the side of the road and say, here, let me tell you my story, and I want you to tell me that I'm in the right, the other side is in the wrong, and I want you to rule in my favor. Is that going to happen? No. So here are the 5 most common mistakes I see, and these aren't just mistakes that everybody does, such as, not copying the other party on an email to the court clerk or something like that, that really doesn't have any major effect. These are 5 mistakes that really piss off the judge and can really prejudice the judge's opinion against you in your case and cause the judge to be biased against you in future decisions. So don't do these. Stick around till the end because the last one is one that I see women do a lot, and it comes from a good place as it's something they do in the very beginning and it's something that hurts them throughout the entire case. So stay till number 5. Number 1, when you go to court and try to get the judge to help you micromanage the other parent's parenting styles. Now, I get it. You may have been the parent who carried most of the parenting load. Typically, there is one, and typically it is the woman. And not always, but typically this is how it goes. And what happens is you come from a household where you literally did everything. You asked your partner to help you with everything. And then there's this concept of weaponized incompetence where he didn't help you really with anything, or he would do basically a half-assed job so that you would have to step in and either help or micromanage him so that he could do it. And then, of course, then the dialogue happens where you're a nag and you're always on his back and whatnot. And then all of a sudden, he does not want any kind of input or help from you when you two have split up and things are really not being done in a way that you would have expected them when you were together cohabitating. You then take on the role that you have always taken on, and that is providing input, providing feedback, trying to help, trying to provide guidance. And when he doesn't listen to you and things keep going in a way that you do not like, you go to court to seek help. So a lot of common examples where I see this are the way that the children are being fed. The children are not being fed in a healthy way. The children are not going to bed at a reasonable hour. The children are playing video games too much, way too much tablet time, etc., and you don't like it. The grades are slipping, things like that. Well, judges do not step in and tell a parent how to parent. The primary purpose of a family court judge, if you're in the process of helping people get divorced, is to split up the assets and to figure out the major decisions as it pertains to custody and visitation and holiday visitation and who's going to pay for the insurance and things like that. When it comes to who makes the day-to-day decisions for the kids, well, when the kids are with each parent has the right to make decisions for the kids. And this is a really hard pill to swallow, especially for the parent who has been kind of the CEO of the family. But parents have a constitutional right to make bad decisions for their kids. And there's nothing that really you can do about it so long as there is not a major health and safety issue for the kids. For instance, parents can feed their kids fast food every day of the week if they want. The only way a judge would step in is maybe if the kids had an allergy to certain foods, which I have seen before, where a father completely ignored the fact that his son had major allergies to seafood and would take him to Red Lobster and would kind of ignore when he would go into anaphylactic shock. So that was a case where obviously the court would step in and say, no, you have to abide by what these medical records say. Another one is smoking. If a parent smokes, the judge isn't going to tell that parent to stop smoking. The judge might say, you can't smoke in the car with the child, you can't smoke in the house when the child is there, but overall, the court isn't going to say you cannot smoke in your own home, even though we all know that cigarette smoke gets into fabrics and things like that, and that the secondhand smoke can get into people's lungs after the fact. So it's not perfect, it's not ideal, but that is what it is. It's something that, as the parent who has done all of the heavy lifting, it is a hard pill to swallow, that you do have to release a lot of that energy, that you cannot control things in the other parent's home. But when you go to court and you try to get the judge to be your ally to help you enforce your rules and your standards in the other parent's home, judges really do not like that unless there is a significant safety and health issue posed for the kids based on this parent's method of parenting. The second thing that people do that really upsets family court judges, and I don't understand this one at all, is when they get emotional in court. Family court judges it's kind of like, don't sit by the pool if you don't want to get splashed. People are going through one of the most difficult things in their life when they're going through a divorce or a custody battle. And I'm always blown away at how little patience judges have for people's emotions during these unbelievably difficult times. But when somebody becomes emotional in a courtroom, a lot of times judges, they get annoyed with it and they deem that parent the problem. That's the troublemaker. They're the ones who are causing the issue. Meanwhile, when the parent who is calm and collected and keeping it together can stand there with a smile on their face and on the outside be very cool and collected, even though that parent might be the one that's completely riling the other one up behind the scenes, that parent is the one who is deemed to be stable and in control. And it's completely unfair and it's completely not right. But if you know this information, then you have to act according to this. And as difficult as it is to keep yourself together during such a difficult and emotional time, it really is imperative to keep the judge on your side. These are your kids. You love them so much. You would do anything for them. You would die for them. You would kill for them. That is how much emotion that you have. The judge does not care about your kids. The judge is a stranger to your kids. You have to keep that in mind. Most states have laws that say that any decision that the judge makes pertaining to the child, they have to filter it through this best interest of the child standard. But the best interest of the child standard leaves an insane amount of discretion to the judge, where they can really go either way. Emotions are messy. Judges like everything to be nice, and a lot of my clients always say, but the judge doesn't care about this. The judge doesn't care that he doesn't like going over to his dad's house. The judge doesn't care that dad doesn't do homework with him. And I'm always forced to say to my clients, you're right, the judge doesn't care. And I hate saying that, and I feel very callous doing so, but the judge doesn't. The judge hasn't even met your child. Why would the judge care about your child? The judge is a worker like everybody else, showing up to get a paycheck. So of course the judge doesn't care about your child. And they will never have the ability to care about your child, because they will, 99.9% never meet your child, and 2, never have the ability to spend the time to even learn enough from the pleadings and the discovery or the trial and the testimony to get a sense of who your child is and his or her strengths and weaknesses and the important things about your child. So stop thinking that the judge cares. The judge doesn't care. So get over that and pull yourself together and stop being so emotional. And I know this is a little bit of tough love, but the second you get emotional, you are biasing that judge against you. The third thing that people do that really pisses judges off is when they start diagnosing their ex with psychological or psychiatric conditions. So the biggest one right now is narcissist personality disorder. And I throw that word around a lot because you can read about it and you can see those traits in your ex, and that's fine. And that can help you a lot on your healing journey. But when it comes to bringing that up in family court, that is a big no-no. Narcissist, sociopath, psychopath, bipolar, all of these things, they're not going to get you anywhere. And the big takeaway is that just because your spouse or your partner was a bad partner doesn't mean that that's going to count against them in a custody dispute. The hardest one is when somebody cheats. That does not mean that that is going to count against them when it comes to the judge making custody orders. But when you call out your ex for something that is a clinical diagnosis that needs to be diagnosed by a professional, you look dramatic and histrionic, and you look like the quote unquote crazy one. And I hate saying that, but that is what judges will think about you. Unless there has been a professional diagnosis from a psychologist, a psychiatrist, or some other mental health professional, do not ever use these words because it makes you look like you're grasping and you're reaching. The important takeaway from this is to use facts and words. So don't use generalizations. He always does this. He always thinks of himself first. He always yells at me and he always blows up in anger whenever I say anything. No. Give factual examples of things that actually happened. So, for instance, I sent him a text message that said, I'm going to be 10 minutes late, and he responded calling me a bunch of expletives, and then show the judge the text message. So, show, don't tell. That is going to keep you in the neutral zone, and you're focusing on what the other person's behavior is rather than your interpretation of the other person's behavior. Because guess what? The judge doesn't care what your interpretation is and what their interpretation is, because your and their opinions of each other is always going to be biased. You guys are going through a divorce. Of course, you're angry, you're messy, all these messy emotions are going on between the two of you. Your opinion is not reliable and is not credible. Your opinion, the same thing with the other party, is not reliable or credible. But if you can show actual factual circumstances that happened, then that is going to pull a lot more weight and credibility with the judge. Now, if somebody does have an actual diagnosis of bipolar disorder, schizophrenia, and if there is a history where this could affect the children, it affects the welfare of the children, then that is something that should be brought to the judge's attention, but it should be done in a delicate way where you're not picking on this person for having a mental health issue. The fourth thing that people do that really upsets family court judges is when you try to find loopholes in their orders, or you follow their orders so closely to the letter that it becomes unreasonable. So what I mean by that is that, let's say you have a long distance visitation schedule and dad is able to come pick up the child starting on Friday the 1st. And it just so happens that, the child is out of school anyway, so it's not going to affect the school schedule. It's not going to affect any extracurricular activity schedules. But the flights are $400 cheaper on Thursday night. And you say, no, I'm not going to agree to that because you can't come until Friday morning. If you were not to agree to something like that, that is going to make you look really bad in the eyes of the judge because you are following technically to the letter of what the order says. Now, will you be held in contempt? No, because technically you were following the orders. However, is that going to get you any favors with the judge moving forward? Absolutely not. And is the judge going to find a way to make up that financial penalty for the other party? Probably. And that's the thing, is there's always a way for judges to find a workaround. So the takeaway for that is to be reasonable. Just because you're compliant with the order is not your get out of jail free card. It's still going to harm you in the future. And you have to think, especially if you have young kids, you're going to be back in front of this judge. So just be reasonable. Number 5. So this is what happens when people initiate their own divorce. And I see a lot of moms do this. And then they reach out and hire an attorney. And this one is kind of controversial, and this one might surprise you, but I see why a lot of women do this. This happens in a lot of cases where dad takes off and leaves her with the kids, and there's very minimal contact, but still some contact. So he'll call once a month to talk to the kids. Maybe he sends $20 to her here and there, but it's a very, very minimal effort to help her and to stay in contact with the kids. But as long as there is some kind of effort, don't do this. A lot of women will file for divorce or for custody rights and request sole physical custody. Physical custody refers to where the kids are living most of the time. So in most jurisdictions, sole custody means if I have sole custody of my kids, the other parent has zero rights to see them. It is 100% in my discretion. So I could say, screw you, you don't ever get to see the kids and you never get to see them for years. And then there's nothing that anybody can do about it. There's nothing that dad can do about it. He can't go to court because the judge has already said it's 100% at my discretion. This really only comes into play when one of the parents is off doing drugs. They don't come to court. They don't try to enforce their rights. They don't really want their rights. They have serious psychological, emotional, financial, physical problems that really has kind of taken them out of the game, and they don't want to be in the game. It's really reserved for those very, very extreme circumstances when a parent is MIA and they don't want to be part of their kids' lives. The next level is primary physical custody, which that definition depends on what jurisdiction you're in. Where I am, it's anything more than 60-40. So if one parent has the kids more than 61% of the time, then that's kind of where we say that, okay, that parent has primary physical custody, the other parent has visitation. And then anything 60-40 or less, because nothing is ever fully 50-50, that's considered joint physical custody. So a lot of moms, rather than asking for primary physical custody subject to dad's rights to visitation, they will ask for sole physical custody. Judges will come down on the moms for this, and because they look at this as an act of control. They look at this as mom saying, I don't want dad to be here at all unless I say when and where. And if I say dad can't be here at all, then what I say goes. I look at this as a woman who doesn't, first of all, know what the definition of physical custody is, the levels of sole, primary, or joint. And also a woman who said, well, look, he left and abandoned me and he's not really doing anything for me or the kids. So I really think it's just misguided on the women's part. But at the same time, the judges will look at this as an act of aggression almost. And I see the pendulum kind of swing the other way, where the judges seem to have sympathy for these men who, by all accounts, have been absentee parents. And there's this kind of hostile attitude from the judges towards the mothers. And I don't think it's fair, but at the same time, this is something that you need to consider if you're going to file for divorce on your own or custody on your own. So how do I know all of this? I've been practicing law for 15 years. I've been a part of probably 1,000 divorces at this point in my career, and I've seen a lot. And these are very clear patterns that I've seen in my practice and sitting through all those cases in court. If you like this video, I'd appreciate if you subscribe, and I hope to see you in my next video. Thanks for watching.